Thank you all very much for being here. We really appreciate it. In the 1980s, Washingtonians working at the Hanford Nuclear Reservation were exposed to unknown harmful vapors escaping from tanks containing untreated nuclear and chemical waste, and they were getting sick. We did not know exactly when and why these workers were being exposed to these vapor releases. In 1992, the United States Department of Energy commissioned the first in a long series of studies and reports to pinpoint what was going on. What we know today, some 25 years later, is that neither the Department of Energy nor its contractors have followed through to finally fix the problem and keep our workers safe. If you visited Hanford today, you'd find some workers at the tank farms still exposed to vapors seeping out of these tanks. These tanks contain an alarming amount of nuclear and chemical waste, enough to fill 88 Olympic-sized swimming pools. 1,500 volatile chemicals have been reported in the headspaces of the tanks, and exposures to these chemicals can cause a range of health effects, from lung disease to nerve damage. Workers have experienced nosebleeds, headaches, difficulty breathing, burning skin, and nausea. Several workers have long-term disabilities, including permanent loss of lung capacity. I stand here today, 23 years, 19 reports, and at least 120 exposed workers later to say we're right back where we started in the 1980s. Enough is enough. It's time for a new and more aggressive approach. This morning, I filed a lawsuit against the U.S. Department of Energy and its contractor, Washington River Protection Solutions, over hazardous tank vapors at Hanford that threaten the health of the men and women of this state who work at Hanford. I'm joined by a large number of folks. I want to particularly introduce two other folks who will be speaking, and a member of my team who will be assisting with questions. So on my team, someone many of you already know is Senior Assistant Attorney General Andy Fitz. Andy's right over here. Andy, as you know, for those of you who know him or worked on this issue, has been in our office for a number of years and is our lead on all issues related to Hanford. I'm also joined by Tom Carpenter, Executive Director of Hanford Challenge, which today filed its own lawsuit against the same defendants. So a separate lawsuit filed by Hanford Challenge. Tom will speak about that shortly. And also Steve Lewis. Steve is right here, who worked at Hanford. He'll be speaking as well. We're also joined by other folks from the Hanford Challenge legal team and other folks who have worked at Hanford as well. I'll briefly give you an overview of the issue. Tom will speak about Hanford Challenge's work. Then we'll hear from Mr. Lewis, who we're really fortunate to have here today to speak about his own experience at Hanford and share his story. And then, of course, we'll open it up to some questions. The Department of Energy self-regulates worker safety and oversees its contractors' worker safety programs pursuant to federal law. As I mentioned, reports of workers getting sick at Hanford date back to at least 1987. And 19 reports have been issued about worker safety and the vapor problem since 1992. 19 reports. Here they are. 19 of them. 19 of them. And we're right back to where we started. We've got a visual, which after the press conference we'll let you take a look at, but there's a visual here, a poster board of all those reports since 1992 looking at this problem. In a tank vapor assessment report issued last year, one of those 19 reports, Energy's own panel, so this is a panel established by the Department of Energy, found, I'm quoting, that ongoing emission of tank vapors, which contain a mixture of toxic chemicals, is inconsistent with the provisions of a safe and healthful workplace free from recognized hazards. The panel further went on to say and found that the data, quote, strongly suggest a causal link between the chemical vapor release and subsequent adverse health effects experienced by tank farm workers. Look, it's easy to get lost in technical issues and jargon when speaking about anything related to Hanford. So let's not mince words. These vapors are a witch's brew of toxic substances left over from producing plutonium for nuclear warheads. Workers have been allowed to inhale these vapors for at least 30 years. You don't need to be a nuclear physicist to know that more reports will not solve the problem. Despite 19 reports, workers continue to get sick. Since the spring of 2014, more than 50 workers have suffered from possible exposure to chemical vapors. On August 14th, just 2 or 3 weeks ago, an instrument technician at a double shell tank farm was exposed to apparent vapors. I understand he was not wearing any type of respiratory protection because none was required in the double shell tank farm. Despite these decades of studies and reports assessing the danger, there is still no lasting, enforceable solution in place. The risk these workers face is very real, and I intend to make the federal government honor its obligations to protect them. That is why I'm filing a lawsuit today under a federal law, the Resource Conservation and Recovery Act, often referred to as RCRA. This federal law allows persons, including me as Attorney General, to bring actions against a party whose hazardous waste practices, and I quote, this is the standard which we'll be asked to meet, quote, may present an imminent and substantial endangerment to the public's health or the environment. We believe we will meet that standard. This is the first time we believe our office has used RCRA to protect worker safety. This lawsuit, I want to point out, may be obvious, is of course distinct from the lawsuit we have ongoing right now, the litigation we have ongoing right now around the cleanup at Hanford. This is a separate lawsuit. In addition, in that lawsuit, the cleanup, we represent state clients, like the Department of Ecology. In this case, the Office of Attorney General represents the people of the state of Washington. Under RCRA, they're our client. And while cleanup issues at Hanford have been litigated in the past, this lawsuit is the first time litigation has been brought to protect workers at Hanford. This is the first litigation on that issue. My goal is to obtain a legally enforceable agreement in court, or court order rather, that commits energy to putting in place all necessary protective measures to protect workers now and the future. In short, number one, stop the emissions. Number two, make sure we have administrative controls. In other words, monitoring to make sure we can track, and a warning system to make sure we can track what's going on. Number three, the use of personal protective equipment. Number four, independent oversight of what's going on there related to worker safety. And number five, accountability. What I seek is a court order or an agreement that allows me, as Attorney General, to bring the federal government and its contractors back into court if they do not honor their obligations under that agreement, with additional consequences if necessary. As with any litigation, of course, I hope we can avoid a lengthy court battle, and I've instructed Andy and our team to continue to keep a dialogue open with the Department of Energy. That said, I want to be clear, that said, conversations and reports have not solved the problem, and I'm prepared to do whatever is necessary to ensure the safety of our fellow Washingtonians who work at Hanford. As a final note, we just were chatting actually before the press conference, and I mentioned to Tom and the others here that here's the way I think about this issue. I'm from a large family. I've got 6 siblings. And the way I think about it is my approach to this case is, what if one of my siblings worked at Hanford, right? What if that was one of my brothers or my sister who worked there? That's the approach I want to take to this issue. And I would strongly encourage the Department of Energy, the leadership of the Department of Energy, and its contractors to take the same approach. Imagine that Hanford was located at Fairfax, Virginia. Imagine it's their child, it's their brother, it's their sister, it's their mother or their father who works there, and to bring the same diligence and focus and attention that they would if one of their loved one was there. Because the reality is, all these folks here are part of their own family. And that's the attention I think it's going to take, and the will that it will take to solve this problem once and for all. With that, I'm going to turn it over to Tom. Appreciate all the work you guys have done at Hanford Challenge, and look forward to your comments.
Okay, thanks, Bob. Thank you, Attorney General Bob Ferguson. And I just want to start by saying your leadership on this issue is very much appreciated by the men and women who are on the front lines of the cleanup of the most contaminated site in the nation. In 1992, an expert review was conducted at Hanford, and it said, failure to characterize the work environment and develop effective engineering controls to minimize or alleviate the chemical vapor exposures is a problem. The need for characterization of tank vapor emissions and modifications of the ventilation systems was documented as early as 1987, but these actions have still not been accomplished. That was a quote from a 1992 document. As a result of ongoing exposures, other such reports and recommendations were made throughout the decades since 1992. Yet, in 2015, as I stand here today, Hanford has still not succeeded in developing a compliant program that adequately protects Hanford workers from potential toxic vapor exposures. We are bringing this action today, our own action as Hanford Challenge, and Local 598 of the United Association, Pete Nicasio is here, to end this familiar cycle. It starts with numerous worker exposures at Hanford. It's followed by media attention. Then you have congressional inquiries. You have groups like ours demanding accountability, and that results in an expert report. And the expert report says, wow, you're doing it wrong, Hanford, and here's a set of recommendations that you need to take in order to protect workers. Now, that's been happening since 1992, and we are still yet not there today. And these promises don't mean anything to the workers who are being exposed again and again and again. That cycle is ending. This cycle has happened at least 4 times since 1992. And I just want to emphasize here that workers exposed to these toxic vapors, some of whom are here in this room behind me, have suffered serious long-term health effects, including brain damage, lung disease, nervous system disorders, and cancer. Some workers are on long-term disability resulting from chemical vapor exposures at Hanford, with illnesses ranging from toxic encephalopathy, neurological damage, nerve damage, lung disease, and others are still fighting for their claims to be recognized. The lawsuits filed today have one common goal: protect the workers conducting one of the most important and dangerous cleanup operations in the nation and end the toxic exposures at the Hanford site. Hanford officials have told us that they have taken protective measures, but they have not gone far enough. And exposures are still happening, though Hanford has quit publicizing those exposures. We're concerned about the short and long-term effects from exposures to such chemicals as mercury, dimethylmercury, NDMA, and another long list of other such chemicals. Hanford still cannot measure these chemicals in real time, the presence of these chemicals in real time. When an exposure happens today, Hanford cannot say what chemicals workers have breathed in, at what concentrations, resulting in what health effect. And that's the same as it has always been. And so workers are left to wonder, their doctors are left to wonder, what happened? And that's got to stop. And in the meantime, workers need to not breathe in these chemical vapors. It's Russian roulette for these folks. It's a toxic roulette. And again, workers are the ones who are the losers. It's time to change that game and put in place legally enforceable requirements that require Hanford officials to protect tank farm workers. Hanford Challenge is very proud today to stand with UA Local 598, Pete Nicasio, which represents the welders and pipe fitters at Hanford. Under Pete's leadership, who's a business manager of Local 598, UA 598 is the only Hanford union with the courage to stand up to DOE and insist upon their workers always wearing protective masks whenever working in the tank farms. And as a result of that union and those workers have been punished for its safety stance, and work has been taken away. And again, this shows how Hanford really, what it really values. Is it really valuing safety, or is it really valuing getting the job done quickly and cost savings? Nonetheless, Local 598 and Hanford Challenge are standing together in this lawsuit. Hopefully the legal actions filed today will get us to the point of getting to a cleanup at Hanford that is protective of the workers. So it's very urgent that this cleanup happen efficiently and in a manner that protects all people and ends the rounds of sickened and disabled workers. So at this point, I'd like to introduce Steve Lewis. Steve Lewis is an electrician who worked at the Hanford tank farms. I've known Steve for quite some time. He suffered a series of exposures at the Hanford site and became very ill as a result. And his advocacy on this issue led to investigations and reports like the type that Bob has just talked about, and I've talked about a little bit from NIOSH and DOE and other sites. And Steve, I'd like you to come up and say a couple of things about what you've been through out there. Steve Lewis.
Okay, thank you, Tom.
Thanks, Steve.
I've worked in the tank farms for a total of 8 years. I was a very excited person to have such a great job and to work in that place. I was born in the Tri-Cities. I know the Tri-Cities has contributed its fair share to the nuclear industry and defense of the nation and all that. But right now, we have a situation where it's abandoned, and it's left over in eastern Washington to decay. It's not being attended to. The tanks are aging. I have no idea of what the plans are out there. Nobody speaks of the plans. There are tanks that are apparently leaking or in bad repair, and the transfer systems are getting old. They're building a plant to process the waste, and that plant is, in my opinion, in some jeopardy because I don't believe that it's being managed correctly. I know that they've lost a $1 billion building just because they have a design build, and I don't know anybody who would go out and start building a house without a plan, but they're starting to build $1 billion infrastructures over there without some designs completed first. And we're lost in this process over there. This place is in jeopardy right now. I have no idea what the plan forward is, but I don't think that we're going in a good direction over there. I've been in the tank farms. I've had exposures. I know what some exposures can do, but there are other people that know what exposures can do a lot worse than what I've had. I've experienced burnt skin from inflamed skin and continual congestion in my throat from a chemical burn, and I've watched other people deal with things out there that are way worse than that. We really don't want this in our state. We don't want it in our ground anywhere in our nation, and this is an abandoned project. I think it's being ignored, and I think we are on the right track to say something right now about it. So,
Thanks, Steve.
Yeah.
Appreciate it. So with that, we'll open up to questions. Thanks, Steve, for your comments. And with that, we'll take questions here. And just for those on the phone, we'll start with a few questions here in the room. We'll then turn to folks on the phone, then we'll come back to folks here in the room.
Mr. Nicasio, Tom had mentioned about the local being punished for raising safety concerns. Can you elaborate on what the safety concerns were and what the punishment was?
Can you introduce yourself for those on the
Sure.
phone? Yep.
My name is Pete Nicasio. I'm the business manager of Local 598 Plumbers and Steam Fitters in Pasco, Washington. I think what Tom's referring to is we've taken a stance out there that we're going to be, all of our people are asking for supplied air while they're working on the tank farms. By doing so, we're ensuring that our workers are safe regardless of what has been put in place. What happens out there is they set different levels, and you can go above those levels, and we've chosen to do that. And by doing so, since we've done that, we have had no exposures to our members, although people around us that are not wearing that supplied air have been exposed. By doing so, it prolongs the job a little bit because you're wearing fresh air, and then also it's more costly. And that's where the problem is for the local. When it starts costing, when we start getting written out of work packages, and our work that's traditionally ours goes to other crafts because it's going to cost more, and it's going to take a little bit longer to use the equipment, the safety equipment that will ensure your workers are safe. DOE is more concerned about schedule and cost than their worker safety. And because of that, that's why part of the reason why we're here today. Okay, by what I mean by punishing is when they take the work from your people that's traditionally yours and give it to another craft, that's punishing you. Or when they say, will you two guys go into this tank farm and do this work? And you say, yeah, but I want fresh air. And they say, okay, stay right there. We're gonna go get somebody else that's willing to do it without the fresh air. That's the punishment I'm talking about. Because
let me ask, get a lot of folks here. Let me get them around. We'll come back around.
Okay.
Yes.
Or if I could just get Pete.
Yep,
Sure,
that'd be great.
that'd be great.
Go right ahead. Yep, that'd be great.
Can you explain the sort of legal rationale for filing separate actions over the same issue?
Sure. So the question for those on the line is if we can explain the legal rationale for two separate lawsuits, and I guess maybe each of us can speak on our own way. Andy, do you maybe want to address from our standpoint why that there's the state has a separate a litigation approach?
From our standpoint, we are not just a citizen plaintiff under RCRA, but also a regulator. And traditionally, we try to keep that role distinct from other parties because we have an interest in maintaining the hazardous waste regulation and litigating the case in a way that we feel best upholds our regulatory authority. So it's more a protective stance on our part, and it's something that's routinely followed not just by the state of Washington, but by the federal government as well.
Do you guys want to add anything on your end? I mean, each entity has their own interest, but yeah, do you want to add? Yeah, feel free to introduce yourself as well for those on the line.
I'm Meredith Crafton, an attorney with Smith & Lowney and representing Hanford Challenge and the local 598. And we felt it was also important to file an independent action on these issues, representing workers specifically, Hanford Challenge members or workers and the members of the union, in order to specifically further their interests. We have a few distinct interests that include seeking medical monitoring for workers who have been and may be exposed in the future. And so there are just that interest of specifically representing the workers at the site versus just protecting, the regulatory interests. So we think it's a really good alliance that these things are happening cooperatively, but they do have kind of distinct representations and purposes.
Thanks.
Sorry, one sort of semi-related.
Yeah.
Obviously, the state's goal here is to have Hanford cleaned up.
Mm-hmm.
Can you just talk about how this does or doesn't sort of dovetail with the other action that get consent decree?
Sure. So the question for those in line goes to how this action related to worker safety dovetails or is connected to the separate litigation track around the cleanup at Hanford. And I think what I'd say is that well, they are related in the sense they're both connected to Hanford, right? They are separate litigation, one focused on cleanup, right? There's references by Steve, for example, to leaking tanks that are there at Hanford. And the cleanup is well behind schedule. That is one legal concern that we have, that I have, and it's the result of a lawsuit on the cleanup side. This issue, while related to Hanford, and the work obviously going on to clean it up, clearly connects to worker safety, separate area. RCRA is separate federal law that we're utilizing. So while they have the same, while some of the facts may be the same, the background may be the same, they are very separate litigations with separate things that we are asking. So I went through sort of a list of things we're asking from in this litigation. Many of those are separate. One thing I would say that is common in a certain way is that with the cleanup side, without getting too much in the details, what's going on now is we are going back into court. Andy and his team are going back into court to ask a federal judge to make the federal government honor a prior agreement, a consent decree, a court-approved agreement as a result of a prior lawsuit. As a result of that prior lawsuit, we're able to take the feds to court and say, hey, federal judge, they're not following that agreement, and ask for them to hold them accountable. Right now, we don't have that when it comes to worker safety. As I mentioned before, there's been no litigation at all. So one of my goals of this lawsuit is to achieve something similar, right? An agreement, a legally enforceable agreement, court order that allows myself or a future attorney general down the road, if the federal government does not meet its obligations when it comes to worker safety, that we can then take them back to court and there'd be additional consequences as a result.
Two questions. First, have there been any long-term hospitalizations or deaths from the 120-odd vapor exposures? And second, I think part of the reason for your lawsuit, I think it was in your press release, said last time DOE got back to you, it had a plan but had no details. And I wanted to see if I could get you to elaborate on that as well.
Sure. The first question, just so folks online could hear, went to how serious have the injuries been to workers? Have there been any deaths, for example? And Tom, do you want to take that perhaps?
Yeah, so there certainly have been hospitalizations, and a lot of the folks behind me have gone to the hospital, have had their cases diagnosed, so they've had diagnosis from doctors with things like toxic encephalopathy, lung disease, and issues. Some have filed worker comp claims, have gotten permanent long-term disability. So absolutely, the courts and the medical profession has recognized, the injurious effect from exposure to these toxic vapors. They're kind of at a disadvantage because Hanford doesn't measure these vapors in real time. Doesn't even have an industrial hygiene tech around with the equipment necessary to be able to measure those kind of chemicals. So that a lot of times their doctors are having to look at the list of chemicals known to be in these tanks and marry up the symptoms that they're looking at and putting it together that way. And we hope to get beyond that. Now there have been some deaths, and Gary Saul is certainly one of those deaths that people attribute to exposure to toxic vapors. He died of, yes, a toxic encephalopathy case. It's swelling of the brain from industrial chemical exposure. His family did get compensation for that. There have been a few other cases, and it's undetermined, right, in a way, but we're certainly worried about the long-term effects of these. Some of these folks up here will probably talk to you about what they've been through. We do have some of those diagnoses available to us and can share. What was the second part of the question? I think it was for you.
I think I got that. So on the second part, which I'll try and summarize as I recall, I think you're asking on my views of with the implementation plan that the Department of Energy panel put forward, my lack of satisfaction with the detail around that. Is that essentially what you're getting at? Yes. So I think that's, so I can elaborate on that a little bit. Look, after 23 years, what I'm looking for is specificity. Let me try that again. What I'm looking for is specificity and accountability. I appreciate some elements of the implementation plan. I think our team agrees with that. That said, it is vague in parts, and there is not specificity in terms of when the Department of Energy and its contractors will get the job done. And that, I think, is what's missing. In contrast to sort of your question earlier about the cleanup, hey, with the consent decree, we've got that level of specificity, right? We've got dates by which certain things must happen, and when those deadlines get missed, we now are back in court saying, look, Judge, they've missed these deadlines, and there is something specific that someone could take a look at. We don't have that in any way, shape, or form right now when it comes to worker safety. Let me take a couple questions from folks who might be on the line. So folks who are on the line, feel free to jump in with any questions you might have.
The conference has been unmuted.
This is Cal Burton from the Seattle Times. Could someone, Tom or perhaps the union official, walk us through in a little more detail what they think would be a safe working environment, what has to be done, what is when you take the air, what is that? Is that a mask, a canister? And are others then, do they have any protection? Do they have any sort of mask? Just give us a little more description of what steps you feel need to be taken, and then what the current situation is. I think that would help us.
Did you guys hear the question all right? Okay.
Okay, so the currently right now, workers as of November or so of last year are required to use supplied air canisters while working around the single shell tanks. So these are the 167 or so, 149 or so single shell tanks below the ground. And however, there are exceptions to when they have to wear that. So we found that out recently. And the so-called double shell tank farms, it is not required. So now we've had several exposures happen. So what we like to see is supplied air, or fresh air as it's called, available and required for all tank farm operations out there. And we don't agree that it needs to be heavy canisters that are dragged around. They have something called carry-alls. You can wheel an oxygen tank. You can run a hose from a bigger tank. All these things have been done at the Hanford site in the past. And I think that is a necessary step until Hanford can get to a point where it can filter these vapors. That's called an engineered control through charcoal filters and other chemical scrubbers that are there to clean the air before it gets to the workers' lungs. There are also other ways that you can monitor and warn workers to get out of the way. For instance, when you know that there are chemicals coming out of the tanks. Hanford is studying all that, but until they study that and get to a point where they actually can guarantee that this is working, there does need to be a level of what's called PPE or supplied air available. They're not doing that right now, and we don't think that they actually get some of the issues here. Like some of these chemicals are dangerous in such tiny quantities, almost molecular quantities, like dimethylmercury. We know it's present in the air, and Washington State has a very tough standard, and there's a very tough standard under NIOSH and OSHA limits as well. I have no idea if they're meeting it. Yet we know dimethylmercury is coming out of these tanks, and we are talking trillionths of a gram can be a dangerous amount to be exposed to. They need to get there or figure out how they're going to get there before they take people off of the supplied air so workers aren't breathing these kind of vapors.
And that was Tom, of course, speaking. Other questions for folks on the line?
This is Annette Carey with the Tri-City Herald. Could you explain a little bit more about what you're seeking in the injunction? I don't understand what work or what activities might be, the court might be requested to stop.
So, Andy, I took a shot at that earlier. Is there any more you want to maybe add to help, maybe in terms of what we're seeking from them in terms of on the accountability side and the rest? I'm going to have Andy take a shot at that as well.
So I don't want to go into too much detail in terms of what will be coming forth in the litigation, but what I do feel comfortable in saying is that, and Bob has already mentioned this, there are sort of three levels of worker protection. The best protection is to not have vapors get out into the environment where people are potentially exposed. The second level is in administrative controls, like Tom was mentioning, monitoring, warning systems. And sort of your last line of defense is with the personal protective equipment. It's that last line of defense that we're relying on right now. What we want to see developed is a program that's more comprehensive in identifying what appropriate engineering controls and administrative controls and maybe better approaches to personal protective equipment could be. Those answers aren't necessarily present right now. One of the conclusions of the 2014 report, and this is actually part of the focus of the implementation plan that the Department of Energy put together, is that those answers need to be developed. The vagueness that Bob spoke about is a lack of specifics as to how we get to those answers and on what schedule and then how they get implemented. So I guess to sum that up, we're looking to take what we think are some good ideas that the Department of Energy has put forward and make them more concrete.
And then, thanks, Andy. This is Bob again. Just to add to that, to reinforce, I think what I mentioned before is taking all those ideas, those thoughts expressed by Andy, and putting that in an enforceable document. It's a court order or a legally enforcement agreement with the Department of Energy. So again, if they fail to meet those obligations, we can bring back in court with additional consequences being the result if they fail to meet those obligations. Anyone else on the line?
Yeah, this is Eric Johnson with Reuters. Maybe I missed it, but I was wondering how many workers have been, what's the thrust of this lawsuit covers what time period? How many workers have been sickened in total? Yeah, that's it. Thank you.
Do you want to maybe repeat the question? This is, introduce yourself.
This is Tom Carpenter from Hanford Challenge, and the question was how many workers have been sickened, and there is no good answer to that. We are tabulating that over the years, and we're up to several hundred workers that have sought medical visits or were evaluated because of exposures, which is a certain threshold of you have to feel symptoms in order to go there. That's a different figure than the number of people who, for instance, have filed worker comp claims and that kind of thing. So I don't have an answer to that, but we are up to definitely hundreds of workers who have reported symptoms severe enough to warrant medical evaluation over the years.
Over what years? Is that recently? Is that
Over the last 10 years.
last 10 years?
Yeah.
Thank you.
Anyone else on the line?
Could I just clarify one last thing that Tom Hanford from the Times? What rough percentage of the work is done with the single cell where the air is required with the fresh air versus the double cell where it's not required?
Can you repeat the question?
What percentage of the work, Hal? Was that the question?
Yeah, it's not, and the numbers of workers that we're talking about that are involved in
I don't know if you can answer that better.
as well.
So,
You can't answer.
the question was about what percentage of work is in single shell tank farms versus double shell tank farms, and I don't have a clear answer to that. There's plenty of work going on in the double shell tank farms. That is the receiving tank farms for all single shell tank farm work, but I simply don't have the answer. I'm kind of turning to my union folks here to see if they know. Do you have any idea, Pete?
I couldn't tell you percentage.
Okay.
I think most of the single shell tank farm work has been done, and now it's double shell, but I can't give you a percentage.
And so I can work on getting you an answer to that, and we'll post it on our website for other folks. But I know there is an answer to it, I just don't have that.
So when we see if we come back to the room here, if folks have a final question too, then we should, Suzanne, I don't think you've had a chance yet to jump in, so feel free.
Unless I missed it, I don't think I heard his steps forward in terms of timing, like you filed this today, and what can we expect
You bet.
down the road?
Andy, from our end, I mean, there's two different lawsuits, but Andy, you may want to walk through the steps to the degree we can.
Sure. Well,
And so if you repeat the question for those on the phone, sorry.
yeah, the question was what we can expect coming forward from the lawsuit side in terms of next actions. The next action is the clock runs for the Department of Energy to answer the complaint. They have to admit or deny or say that they don't have enough information to respond to the allegations in the complaints. We move forward then, just roughly speaking, into a period of discovery where we can seek information from each other. And then that helps prepare the cases for either trying to weed out issues on summary judgment or eventually going to trial. The case schedule it's not determined at this point, and that will be determined at a later point in a status conference with the court.
So how long does Energy have to give you that initial response?
I believe the federal government has, if I remember correctly, subject to check, I think they have 60 days.
And if it were to go to trial, this is a bench trial?
Yeah, it's not a jury matter.
Sort of a one-run impression I have by you guys to see whether I'm getting the right impression. I have the impression that an individual tank farm with all the different companies and unions involved in different projects, that you could have several different protection levels existing at the same time in the same tank farm. Some guys some men and women could be wearing respirators right next to people who are not wearing respirators. Essentially, it's like a real hodgepodge of just whatever the supervisor in charge is in the mood to do. Am I reading that correctly?
So I'll just repeat the question and turn over to you guys. So the question was, paraphrasing a bit, was at the Hanford Tank Farm, it appears that there is, I think in your words, a hodgepodge of sort of different levels of protection or protective gear for the workers, depending on maybe the supervisor or other factors. And is that essentially true, or what's going on? That was the question.
Yeah.
And so Pete's gonna answer that question.
Okay, to answer your question, the tank farms, they're made up of single shell tanks and double shell tanks. The single shell tanks, for the most part, have ventilation systems put in them, and double shell tanks, not necessarily true. Now, what happens out there is there might be people in an area this size that are wearing, my people are wearing fresh air, and Tom's group might be wearing, the guy right next to me might be wearing a canister, mask, or nothing. And also, there's containment ropes, we call them the magic ropes, that there's an exclusion zone. Inside that exclusion zone, everybody's going to be using fresh air. Right on the other side of the magic tape or rope, they're not. Now, where our people, they're all wearing it regardless whether they're wherever they're at in the tank, on any of the tank farms. So that's to answer your question as best I can.
Why don't we do one more question, then we'll, as you haven't had a chance, why don't you jump in, then we'll take one more question. We'll be available afterwards for additional questions as well.
It's more of a summary question,
Yeah.
just a common sense question. I mean, you talk about how there's this cycle, perpetual cycle
Yes.
of reports and nothing gets done.
Yes.
Hanford doesn't do anything. Can you explain to the average person what the teeth of this lawsuit would mean for you? Just
Sure.
Why do you think this will have an effect, whereas decades of these reports haven't?
Good question. So the question, to paraphrase, is what's the teeth behind the lawsuit? What would be different, in essence, of a lawsuit than, hey, the years of reports that we've had? What would be different for the average person to get why the lawsuit can make a difference? And in essence, and Tom or others, feel free to add your perspective as well. From my perspective on this is that the law is a powerful thing, right? And lawsuits bring a certain power to them because you get before a judge, and a judge issues an order, right? And that order must be followed, right? Disobey at your peril, right? Right now, we don't have that. We have conversations, we have a dialogue, we have reports, but there's nothing requiring anyone to do anything, right? And as I mentioned at the outset, the Department of Energy is essentially self-regulating itself at the Hanford tank farms, and that's not good enough, right? This is the tool that I have to hold them accountable. So a lawsuit allows me to get before a judge and to get an agreement that is enforceable by a court, so that if down the road the Department of Energy or its contractors do not meet its obligations, then I can bring them back to court, and there are consequences to not following a court order. That's the teeth. In fact, I'd say it's more than teeth. That's significant. We see that in other contexts. You see it in McCleary, right? You see in other contexts all the time. A court order is something very, very different than a report that comes out from the Department of Energy. And that, to me, in essence, is the power of a court order and seeking relief through the courts.
So it. Example of a consequence. I know that's way down the line.
It's way down the line. So Suzanne is asking, what would be an example of a consequence? I won't, I'm sure Andy does not want me to prejudge that this time, but in general, right, one can have consequences that are financial. There can be penalties. There are things that, along those lines, there can be consequences. And, to be candid, I'm not going to prejudge my approach in this litigation, but I do want there to be some consequences if they don't follow whatever agreement we enter into, either as a result of litigation going all the way to the court or something we work out with the Department of Energy and its contractors. That I do think there needs to be, for lack of a better word, a hammer to them if they do not follow whatever that order that's agreed upon. I think that's significant. Look, just to wrap up, first, thanks Tom, Pete, Steve, and to everybody here, for being here, number one, and for all that you've done at Hanford. We really appreciate it. And just to conclude, what's going on is unacceptable. It is. There's not another word for it. It's unacceptable. And I'm not going to stand for it. And I fully intend to use the authority that I have as Attorney General to protect the Washingtonians who are out there working every day at the Hanford tank farms. And it was mentioned earlier by one of the speakers that is challenging work and difficult work, and those folks are willing to do it on behalf of all of us, right? And I view it as my obligation to make sure that we do everything we can to protect those workers in doing that challenging work. And my expectation is that the federal government and their contractors will do the same. And that is my overarching goal with this litigation. So thanks for being here. We're happy to stick around afterwards and take questions. And thanks again for being here. Appreciate everybody.
So for those on the phone who have questions, how can we get those answered?
If you're on the phone, I would just reach out to Allison is probably the simplest way. And if possible, I'll try and be available myself or we can get questions answered. But I'd work through Allison would be the simplest way. Thanks so much.